Major breaking news, a big win for the Second Amendment in California, believe it or not. In the Central District of California, a win for the Second Amendment Foundation, the Gun Owners of America, and the California Rifle and Pistol Association. Big win on behalf of non-residents of California who are now allowed to apply for concealed carry permits in the state of California. This is the start of what I suspect will be a deluge of favorable rulings over the next year or two in favor of people that want to carry guns in the anti-gun deep blue states. Let's break it down when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Israel Disarmed. For those of you who got free copies that I signed out there in Knoxville, Tennessee, during the Gun Owners of America National Conference, feel free, if you've reviewed the book and you like it or hate it, feel free to leave a review on Amazon. Always interested in reviewing what people have to say about my work. Okay, folks, so good news, not all perfect news, but let's not dwell on anything that's negative for the moment. Let's look at the positive upside here. In the state of California, a federal district court judge, Sherilyn Peace Garnett, an appointee to the federal bench by Joe Biden, Kamala Harris, has actually issued a ruling in favor of the Second Amendment. Specifically, Judge Garnett has ruled that the state of California and the counties therein have an obligation under the Second Amendment to allow non-residents of California to apply for and procure concealed carry weapons licenses. Up until this point, if you were a resident of Nevada, Florida, Vermont, Maryland, whatever, whether you had a perfect record, whether you had top secret clearance from the federal government, whether or not you had a concealed carry permit in multiple states, doesn't matter. You were not able to apply for a concealed carry permit in the state of California. Well, that has now changed with this decision in the California Rifle and Pistol Association versus the Los Angeles County Sheriff's Department et al. Many of the defendants there, local and statewide. Judge Garnett said that under the Second Amendment, obviously all Americans fall within the definition of the people, as in the right of the people to keep and bear arms shall not be infringed. You take a look at Heller, the people consist of, at a minimum, all American citizens. That includes citizens of America that are not residing in the state of California. And therefore, obviously, they're part of the people in the text of the right of the people to keep and bear arms. Obviously, if you want to carry a handgun, that is an arm. She actually did not quite analyze that correctly, but she got to the right answer. We're not going to criticize her for how she elevated certain things that should be at the historical level of the text first, burden shifting to the historical tradition of firearms regulation. She elevated certain things that should be at the historical level to the textual level, but it didn't matter for our purposes in this case because she got to the right outcome, although technically speaking, her methodology was off. Again, handguns are obviously arms, and the right to keep and bear means the right to own and the right to carry. To bear means to carry in public for self-defense. That's what we learned in Heller and Bruin. So obviously, if you're an American citizen, you want to be able to carry a firearm, a handgun, in California, you have a constitutional right to do so. But, of course, referencing footnote number 9 in Bruin, there's a reference there that shall issue permitting regimes may be acceptable or seem to be acceptable. It's a debate for another day. But the bottom line is that California has what's known as a shall issue permitting regime, although it's very onerous. That is subject also to a challenge in this case, but she denied the preliminary injunction on those grounds. That will be something we'll talk a lot more about later, dealing with these discretionary licensing regimes. But again, we're not going to get into that right here and right now. We're going to focus on the silver lining of the fact that you have a Joe Biden judge in the Central District of California, Judge Garnett, saying that non-residents of California have a right to keep and bear arms in California, and thus they have a right to apply for a CCW. She says that textually, obviously, the law implicates the text of the Second Amendment. That shifts the burden to the government to do what? We've talked about it on this channel, and Judge Garnett points out that the burden is on the government to demonstrate there is a long-standing tradition of firearms regulation that would justify this modern-day gun control law, i.e. not allowing non-Californians to carry guns in the state of California. She then analyzed it and said that the only historical analogs that the state had come up with that could conceivably be analogs to justify their modern-day restriction on which prohibits non-Californians from carrying guns in California are 20th century laws that she says undeniably are way too late according to the Supreme Court precedents. So she said, I'm going to reject those. And there was also a passing reference to the Dred Scott decision that, as you may recall, said that blacks, African Americans in the 19th century before the Civil War were not entitled to be citizens or were not considered citizens under the Constitution because if they were citizens, they would have full-blown constitutional rights, including, but not limited to, the right to carry guns everywhere they went. That was Justice Roger Taney's decision in Dred Scott, which the Supreme Court has rebuked in many instances and specifically actually used it in favor of the Second Amendment in the Bruin and I think even in the McDonald cases as well. So anyway, the bottom line is this. If you are not a resident of California, but you want to apply for a concealed carry permit in California, you may now do so. This is a big change and a favorable one. Because as you know, as we sit here right now, there are, I think, 29 states that have, right? It's permitless carry, constitutional carry, whatever you want to call it, okay? And this is great. 29 states, and we should have North Carolina soon. I don't know what's holding up there, you people in North Carolina. You let me know what's going on. But soon, presumably, we should have 30 states that have permitless carry or constitutional carry. And that means we're just left with the 20 other states, and some of those are the really terrible anti-gun states like California, New Jersey, Massachusetts, Hawaii, New York. But we're going to get them too, especially if Donald Trump's reelected. I think that a lot of those laws are going to fall. But we're not talking about what might happen in the future. We're talking about what's happening right now. I think it's crystal clear that your constitutional rights extend across state lines. If I take a vacation in Tennessee or California or Alaska, guess what? The Fourth Amendment protects me if I'm pulled over by police in those states. The Fifth Amendment protects me if I'm pulled over by the police in those states. If I'm arrested and tried in those states for doing something bad, I'm protected by the Eighth Amendment that prohibits cruel and unusual punishments to be inflicted upon me as a criminal. So obviously, as an American, I should be able to go anywhere and exercise all my constitutional rights everywhere, including my right to keep and bear arms. But states like California are trying to resist, and New York was trying to resist, and they're starting to roll over too. So again, is this the Super Bowl win? No, but it's an important next step. And as I've explained to you, precedent establishment is key. Every one of these precedents in favor of our right to keep and bear arms is something we can build on. It's metaphorically the same way as in World War II, the island hopping strategy to take out Japan. You couldn't just realistically just invade Japan willy-nilly by cruising from Hawaii to Japan. You had to island hop. You had to take over one island at a time before you were in a position to take out Japan. Only by doing this bricklaying or island hopping, whatever metaphor you like, can we have full civil rights for gun owners in America, which I think we are working hard to get back to where we were. Remember, we're not trying to advance new rights. We're trying to restore our constitutional order. We're trying to restore the government to where it never should have left. We're trying to restore our right to keep and bear arms that never should have been infringed upon. And it's taken time, but I think we're making good progress and we're moving in the right direction. So let's hope we can keep it going. And this win in front of a Joe Biden, Kamala Harris appointee, Judge Sherilyn Peace Garnett, out there in California, is yet another brick in the wall, another precedent that we can use all across the country to continue to advance our civil right, our constitutional rights, our human right to keep and bear arms and defend ourselves against all forms of tyranny. All right, folks, hope you learned something here today at the Four Boxes Diner. Make sure you follow me on X at Four Boxes Diner. Don't forget to subscribe and like this video, and we will talk to you again very, very soon, I hope, here at the Four Boxes Diner.
Orders up. Table 2A.